Good morning, colleagues. My name is Tondani Chamano, and I welcome you all into the competition law guide joint effort between the SABS and the Competition Commission team, hosted by the South African Bureau of Standards. And the aim of this workshop actually is to sensitize our stakeholders on the issues that may rise or perceived when developing our South African standard to be anti-competitive in terms of Competition Act. And in order to achieve this goal, the SABS, together with the Competition Commissioner, we have published a guide, which is the purpose of this workshop today. And you shall hear more on that as our lined up speakers are going to go through what they've prepared in their presentation, and also on the intro by the executive panels of the SABS together with the Competition Commissioner. Allow me to share with you the agenda for today. We are running a little bit behind. We're supposed to have started our meeting at 10 o'clock, but I see it's almost 8 minutes past 10. But I'm hopeful that we'll be able to recover for the time wasted. The first speaker is going to be Dr. Sadviri on the opening and the SABS remarks. And then the next speaker will be Mr. Andale Kwabeni from Competition Commissioner remarks. And then we have our presenters, who will be Mr. Mashari Peter on the competition law guide from standards perspective. And last but not least, we'll have Mr. Shadrach Rambau, who's going to talk on the competition law guide and will take us through the presentation. Okay, as you have already noticed, the team of the people that's going to be presenting today, they've got wealth of experience and a remarkable expertise in their field that will be in the standards and the competition law, and have a vast experience in both executives and managerial level. Having been said that, I would love to welcome Dr. Sadvir Bison, as he will be saying some remarks about the SABS opening and welcoming address. Dr. Sadvir is the executive of Standard Division. He has held the position of executive for a long time, and he has been serving in Standard for over 20 years. And he has got a portfolio ranging from acting CEO for a period over a year. And he has also served the SABS in the variety of its entities, especially different departments. And perhaps maybe we can, before we can proceed, or before I give the platform to Dr. Sadvir, I would love to advise the participants that we will be recording our meetings, and we have switched off everyone's camera for a reason, just in order to avoid network congestion, so that we smoothly run if we are only using our audio. But for our speakers, they are always welcomed to switch on their camera during the intro as they switch towards their presentation. And this meeting shall be recorded as such. Therefore, I'll give the platform to Dr. Sadvir.
Great, thank you, Tondani. Tondani, I just want to confirm that you can hear me loud and clearly. Tondani, just want to confirm that you can hear me.
We can hear you.
Great,
Sophie.
really appreciate it. Thank you, colleagues. Good morning, colleagues. Morning once again. It's certainly a great pleasure to be part of this very important workshop around the theme of it being competition law issues addressed under the domain of standardization. So, colleagues, this is an awareness session. Just bear that in mind, and certainly where we require additional initiatives as an outcome of this webinar / workshop, we'll certainly engage on those matters. As Tundani has pointed out, my name is Sadhvir Basoon, and I've been at the Bureau for a significantly lengthy period of time, plus minus 20 years in various portfolios. But just to go on specifically in terms of matters and status of the organization, I thought it be quite important that I just give you a brief overview of where we are as an organization. So, colleagues, you may be aware that over the last couple of years, we have embarked on an organizational review process, and this subsequently resulted in a new operating model, subsequently resulted in a new structure. And we've been in the process of populating the new structure over the last 12 to 18 months. I must say that we've concluded the placements, official placements of staff members within the organization, but there's certainly a few areas of further capacitation in terms of resources to be allocated in the organization to fully capacitate these areas to optimum capacity and capability. I fulfilled the role of acting CEO for the last year, January to end December 2023, and this was a directive from the board of the SABS. Unfortunately, we haven't concluded the process of appointing a CEO, and the board took the liberty of a decision that we should continue on a rotation basis on a maximum allowance of 1 year for an acting role in the organization, especially at executive portfolios. So we have a new acting CEO of the SABS, Mr. Lungelo Ntobongwana. He fulfilled the role of Chief Operations Officer for a few years, as well as headed up a number of strategic roles in the organization, including the commercial sector as well. So that's just brief in terms of where we are as an organization. We are attempting to conclude this entire placement process in the coming months, probably 2, maximum 3 months. So we have a complete stability of the organization, and specifically from my perspective is complete stability of resources and requisite resources in the standardization portfolio. I know it's a bit late for the greetings for the year, but I would like to wish all the colleagues who are present here today, and I see the numbers are growing, 179 participants in this event. Thank you for joining. It's certainly a very important aspect of your contribution that we need to engage with as we endeavor and contribute to the various committees, working groups, sub and technical committees in the development of national standards, not only domestically, but more importantly, how we contribute regionally and internationally as well. So as we move on towards creating this stability in the coming months, we've certainly identified that there are few areas in the standardization area that we need to provide priority focus in terms of capacity building, and we do acknowledge that, and we'll certainly endeavor to correct that in the coming months as well. So, colleagues, the objective of this webinar is basically to provide, as Tundani has indicated, an awareness and an element of calibration and understanding of the competition law that has an impact specifically on the standardization area of our work as a national standards body. You would appreciate that SABS, its mandate stems from a legislation, which is the Standards Act, initially Standards Act of 1943, and subsequently amended and promulgated in 2008 as an amended version, which it's currently under implementation. So the key focus today is going to be on the development of national standards and the impact of competition law on the potential and or perceived issues around the development of national standards and where competition law comes in to address those matters that could be potentially or perceived anti-competitive during our process of national standards. Colleagues, there are a number of clauses within the National Standards Act that defines our operations and how we should do things. So it's literally coded in the Act, and Peter Matlale will highlight a few of those clauses from the Act. But one of the key documents that defines our work, which is encoded in the Act, is the South African National Norm. We have an existing national norm. We had, this norm has been in existence for a number of years, literally decades or since inception of the national standards body, and it's currently under review. The focus of this webinar is not to review or interrogate the current version being amended or reviewed, which is the national norm, bearing in mind that we already have an existing document that is under implementation. And the current review document is going through a process of internal quality assurance, and we trust that this will be published in the months to come for completeness sake, because we understand there are a few comments that have been submitted and that we need to consider in conclusion of the review of the South African National Norm. You're also aware that we report to the Department of Trade and Industry and Competition, and we have a very strategic relationship with all entities of the DTIC, and even more so with the Competition Commission. And we've had numerous engagements on a strategic level with the Competition Commission on various matters, on developments, inquiries, and some may be complaints that have been raised and addressed by the Competition Commission on focus areas aligned to the standards development process. They have been very instrumental, and we've been working with them for a number of years on how we address these potential or perceived matter of anti-competitive behavior in our technical committees. And based on that engagement, there was an agreement that we start working together to publish a specific document or a guideline for our technical committee members as a priority, but even more so for other stakeholders that may or may not participate in the development of national standards. The process for national standards, as you are vibrant, some of you new, some of you have a maturity rate of spanning several years in the development of national standards. There's always room for improvement. There's always room for enhancing our processes, and there's always room for further calibration of our processes, which we will do once the SABS norm has been published, which is the amended version of the norm. So our strategic engagement with the Competition Commission allowed us to work closely with them in the recent year, to engage on matters that has been coming in for the last couple of years. We've also provided them with an opportunity to come to our technical committees, and they've addressed the technical committees on guidelines or on a better understanding of anti-competitive behavior, and any issues that were raised were transmitted to the Competition Commission for their address. Colleagues, we at the National Standards Body, we are responsible for making sure that the governance processes of national standards, of the development of national standards, are adhered to. That is key to our focus, and that's why we have a plethora of documents as part of our policy management system, which will be briefly highlighted in further presentations as well. I highlighted the norm. There's other documents, code of conduct, which is quite critical, which every member of the committee has to sign and adhere to the national norm, to the code of conduct. And in addition to that, it's not just signing the code of conduct, it's really appreciating and understanding the contents of the code of conduct, and then executing those roles as defined in the code by all members of the committee. So the code of conduct is a very critical element towards the development of national standards as well. Notwithstanding, it's a process of consensus development, as well as we aspire to ensure that we adhere to international best practice principles of standards development, which include openness, transparency, consensus, effective stakeholder engagement, due process, as well as the element of relevance and market relevance of our documents as we transition them to the committees. In addition to that, we participate regionally and internationally. ISO, IEC, ARSO, APSEC, you'll hear a little bit more on that. And we follow the best practice of ISO and IEC purely because it's part of the WTO Annex 3 obligations as well. And this talks to the directives. So we try not to reinvent the wheel in terms of policies, processes, and systems. As members of ISO and IEC contributing a significant financial amount to be members, and further to acquire the benefits and take leadership roles in ISO and IEC, we make sure that we have the right expertise and leadership capability, both as governance leadership and technical leadership as well, to drive our standardization agenda from the national perspective to the regional and international perspectives as well. So our strategic partnerships with the Competition Commission, as I pointed out, goes on for a significant number of years. And we've taken the opportunity to work much more closely with the Competition Commission in the last couple of months to finalize this publication. And today we would like to present the guideline, and we have two critical areas of presentation of the guideline, which is coming from a standardization perspective. Matlale Peter will guide on that, and a representative from the Competition Commission to talk a little bit more on the competition law and implications of the competition law having an impact on the standardization arena, as well as what we should be on a lookout for from all stakeholders' perspectives on perceived or potential anti-competitive behavior, notwithstanding the number of various rules and processes that we have to follow as part of the national standards body's mandate. In conclusion, I would like to thank all the members who have joined, all the colleagues. This webinar we'll try and keep it as informal as possible, with an opportunity for further questions to be raised at the latter part of this webinar. And working with the Competition Commission has certainly been an eye-opener in terms of really appreciating what things could or matters could be raised or areas that we may not have really engaged on as part of our norm documents that could have an impact on our standards development and with the potential of exclusionary outcomes in standards development or perceived collusion activities by members in the development of national standards. So those are the two areas that we would likely to focus on as we move forward in the discussions. And thank you for once again joining us. I would like to hand over to Tundani once again for the opportunity for opening this meeting and welcoming the colleagues. And I'll transmit this portfolio back to yourself, Tundani. Thank you.
Thank you, Dr. Sadhvir, for that welcoming and the remarks about the SABS. Much appreciated. And now we will move to our next speaker, who will be Mr. Andile Gwabeni from the Competition Commissioner. Mr. Gwabeni is the manager from the Office of the Commissioner. Mr. Gwabeni, the platform is yours. Andile.
Thank you, Chair. I was struggling to unmute. I thank you for providing me that capability. I hope everyone can hear me.
Yes, we can hear you, Andile. You can go ahead.
Thank you very much. My name is Andile Gwabeni. The one that was on the program is my English name, but my name is Andile Gwabeni. I am the manager in the Office of the Commissioner. I'm also the acting manager in the advocacy division, which has been participating in this important process. I would like to greet everybody on the platform and to welcome everybody to this very important workshop on looking at the joint guide for participation in standards development process. As you may know, the Competition Commission is one of the 3 institutions established by the Competition Act number 89 of 1998 as amended, which we call the Competition Act, alongside other competition authorities like the Competition Tribunal and the Competition Appeal Court. The Commission is empowered, as you may know, to investigate, control, and evaluate restrictive business practices, amongst other roles, in order to achieve an efficient and competitive economic environment that balances the interests of workers, owners, and consumers, and is focused on the development of all South Africans. One of the areas highlighted in the stated purpose of the Competition Act is to provide all South Africans equal opportunity to participate fairly in the national economy. Guided by this purpose, the Commission has over the last 2 years interacted with the SABS to draft this joint competition law guide that should be considered by any party that is selected as a member of any standard setting committee. The guide was developed through partnership to facilitate collaboration between the institutions on matters that fall under our jurisdictions. While the SABS is responsible for standards, the Commission ensures that the resulting standards comply with the purpose and the provisions of the Competition Act. Over the last few years, the Commission received numerous complaints lodged against standard development processes. The allegations from the complaints were standard development processes restrict competition and exclude small and medium enterprises and firms owned by historically disadvantaged individuals from participating in a range of markets and seem to favor incumbent and dominant companies. And this is one of the critical reasons why we think this is a very important workshop, so that we can look at how we resolve those issues. As we all know, the importance of the participation of SMEs in fostering growth in the economy, and of course, the participation of historical disadvantaged individuals if we are to create an inclusive economy. The guide provides a basic outline of competition law, compliance, and risk associated with the standard development process. It is also there to provide awareness and guidance to all the relevant stakeholders on pro-competitive principles that should be applied during the standard setting process, and so that they can make sure that the potential harm that may arise in the standard setting process is avoided. In essence, the guide provides the general approach that the Competition Commission and SABS will follow in determining whether stakeholders have collaborated their responses in developing, altering, or modifying standards through the processes that are administered by the SABS. Drawing from this guide, this workshop must therefore provide guidance on conduct that would contravene the provisions of the Competition Act. It must also address practices that participants in the South African National Standards Development process can adopt to ensure the promotion of competition and inclusion during the standard setting process. I would like to thank Chairperson, everyone who has decided to invest their valuable time to this important initiative, and encourage all members present to do everything in their power to ensure that we achieve the purpose of this workshop. This workshop must succeed so that we can all contribute to building an economy that is growing, competitive, efficient, and most importantly, inclusive of all South Africans. I look forward to today's discussions and wish the rest of the presenters very well. Thank you, Chairperson.
Thank you, Mr. Andile, and thank you so much for the opening remarks and also the well wishes for the participants. And we also hope that this is going to be a successful one and a fruitful exercise. Next in our agenda, we have got two presenters. I saw most people, they've been asking of the slides to be shared. The previous speaker were giving the remarks about the SABS and the Competition Commissioner. And the next speakers, they're the one that's going to be addressing us on the agenda of today. And therefore, they will share their presentation as expected from our participants. So the first speaker will be Mr. Mahlali Peter from the SABS, and he will be talking on the competition law guide on standard perspective. Mr. Mahlali is the manager for standard processes and support. He has got a vast experience as well within the SABS. He has served the SABS for more than 17 years in the managerial position, and he holds a degree in engineering. And having been said that, I welcome Mr. Mahlali on the platform. The platform is yours, Mr. Mahlali.
Thank you. Thank you very much, Tandani. And let me also greet everybody who's on the platform. And we welcome you. We also appreciate the time that you made to come and attend this important workshop. Tandani, if you could just confirm if you can see my presentation.
Yes, I can see it, but you might need to move to the presentation mode.
Okay. Right, is that better?
Yes, it looks much better now.
Thank you very much. Colleagues, as Mr. Andile has said, that over the years, there has been complaints from our committee participants to the Competition Commission alleging that there could be anti-competitive behavior going on in our committees. And we had to then work together to say, how do we address that before it even happens? We're happy that to date, at least nothing of substance has been established that indeed that is happening. But the fact that the commission established that there could be such a potential led us to say, let's work together and produce something. So colleagues, you will notice that my presentation will touch on a number of things. Some of them I would just browse through and skip quickly because Dr. Bisoon has indeed touched on them. But you will know, or at least appreciate, the reason why we are approaching it from this angle as the SABS to cover everything, because in the standardization arena, there are a number of factors that comes into place that could eventually then lead to, you know, a forum or at least a platform where there could be issues of competition that or anti-competitive behaviors that arises. We're still operating under the Standard Act of 2008 with the objects of developing, promoting, and maintaining South African national standards, which is going to be our focus for today. Obviously, we also promote quality in connection with commodities, products, and services, as well as rendering conformity assessment services and matters connected thereof. So for us as the Standard Division, and when we go into the Standard Act, our focus, not necessarily limited to this, but these are the sections that applies to us, section 20, 23, 24, 25, up to 28, which talks about the norm that we've touched on, the issuing of national standard, the gazetting of our standards, the recognition of other organizations as standard development organization, copyright of South African national standard, as well as how standards are incorporated in the law. On this slide, Chairperson, I just want to highlight two important issues. First, that we need to all, be on the same page that standards are acknowledged and represent an agreed way of addressing a current or a potential issue. Meaning that when you look into standards and look into technical regulations, which there's a history behind this, is that standards by their own nature are not mandatory, or compliance with standards are not mandatory. There's a number of queries that have been coming to the SABS, especially now and then when you hear that there's a cholera outbreak in Hammanskraal, or kids have eaten something that allegedly resulted in the unfortunate passing, where then you get calls to say, but SABS, what are you doing about that? Unfortunately, we don't have that mandate since the 2008 amendment of the Act. So the technical regulations, that's where compliance would then be sought, or mandatory compliance with those standards will be sought. We develop our standards in accordance with best practice, international best practice, but the Act is very clear that we have to publish this norm that will then set the provisions for how we are going to develop these national standards. As Dr. Bissoon has already said, we are a signatory to the WTO TBT agreement that was signed around 1996 by our government when we started joining this international organization. And that also affects us. And with reference to Annex 3, I know most of you would be aware that we always write in our forward that we comply with this annexure, and at times we'll be asked, what is this annexure? So that is the annexure that guides us how we develop these standards. Obviously, we are members of various international organizations. In fact, we are very proud to say we are founder members of some of these international organizations. We continue to play a very influential leadership roles within ISO, where we occupy 35 of the leadership roles, as well as in your Electrotechnical Commission, the IEC, where we also hold leadership position within our region. Also, we are very influential. We sit in council, we sit in the standards management committees of those bodies, which assist us to contribute towards the realization of this free trade agreement, the African Free Trade Agreement. We also work closely with BRICS, as all of you know that has now been expanded, but that assists us to expose our industries, align our programs towards a common goal of the development of standards. Obviously, at a national level, our collection, we've just exceeded 7,500 standards. We publish over 300 standards annually, and we maintain over 300 committees with many experts exceeding over 2,500 individuals. So very briefly, colleagues, in terms of the benefits of standards and standardization, that, standards forms the basis for regulations. I've touched on this issue of regulations. The standards themselves are not a regulation, but they form a basis for that. So meaning that you don't want to reinvent the wheel. And there are many benefits to that. Now and then, colleagues, once in a while, we call regulators here, we talk to them, just to show them the benefits of standards. Because obviously, if you sit in our committees, you develop standards with us, where you sacrifice a lot of time, you also are interested to know, are these standards that we are developing, are they being used? Therefore, as the SABS working with the regulators, we are able to show them that, these standards, how they can assist you as the regulator to also achieve your own mandate. The standards also contribute to socio-economic development, the increase market opportunities. Those who've been participating in our committees, they know, the benefits that they also derive at a company level, at a national level, when you have to expand to neighboring countries. As an example, I'm aware that at some point, even our neighbors, Botswana, they had to base even their building regulations on our own national building regulations, because again, the principle of saying in standardization, well, we don't reinvent the wheel. But what comes with it is that you don't have what is called the first mover advantage. And I'm focusing on this, colleagues, because then soon as, if I'm a committee member, I can realize, the power that standards brings. Sometimes you can then be tempted to try to bring to the table things that we will say later on in our presentation are not allowed. We also, colleagues, don't just do what we do for the sake of doing it. If you compare us to some of the developed economies, some of the developing economies, I've said we just have less than 8,000 total publications. And I mean, if you look into when was the SABS established, 1945 today, it's because the work that we do, we don't just chase the numbers. I mean, other developed economies, even the developing economies will tell you about, we've got a collection of 25,000 standards. Others will say we've got close to 30,000 standards. And we say, but what does those numbers mean? Therefore, when we do what we do here, we are aligning to international and national priorities. As far as international priorities are concerned, all of you are aware of the UN SDGs, 17 of them, where we are also, when you are proposing a standard to us, we are also then asking a question, to which SDG does this proposal at least align? Which SDG does it support? Same goes with our national priorities, the DTIC priority sectors, where we also ask the same question, can we at least indicate which ones are we supporting, so that whatever work we do, whenever you sit in our committees and you contribute, you know that you are contributing towards the country, not just the SABS, at least helping it to achieve some of these international and national priorities. Just very briefly on our national industry priorities, I've highlighted just the two sections to indicate to you that where there's expansion of the market, there has been for a number of years now debates around cannabis, hemp, and traditional medicine, where we have also then have established a committee to say we need to also, as the SABS, provide a platform where we can standardize or we can develop standards on cannabis and hemp. The issue of circular economy, plastic circularity, and last but the issue of the hydrogen economy, which we are also then expanding into. So as we are supporting these national industrial priorities, we are also looking into the new markets or new areas of standardization that we need to expand into. On the issue of the governance, we've touched on this already, but as I said, at the center, we are governed by the Standard Act of 2008. So the Standard Act, as I've already said, mandates us to develop national norm for the development of standards. We also have an obligation to publish a document which we have to publish it in the form of a national standard. We call it a Sense 1 Part 2, aligned to Section 24 of the Standard Act that says, we have to have a criteria for organizations that might wish to publish standards as well. Obviously, colleagues, we are also saying we have to at all times have some quality in the work that we do. So consistency in the work that we do. Therefore, we have aligned our work or our processes to the principles of Sense 9001, or what people call ISO 9001. And last, as you know, that the Standard Act talks to the issue of national standards, but it also says, as the SABS, you might publish other documents that don't have the status of a national standard. So we have indeed published a document that talks to that. So all of these publications, colleagues, the SABS don't charge you for anything except obviously the ISO 9001. But as far as the ARP, which sets the rules for how we structure and draft standards, your norm, your Sense 1 Part 1, and Part 2, as well as a SATS 2, you are able to get them free from the SABS to empower yourself as to how we do the work that we do. Now, this then leads me to the core of this presentation, which is now on how we cooperate with the Competition Commission. When the whole investigations were brought to us by the Competition Commission, and we took them through our systems, through our processes, then the decision was made to say, then we have to come together and develop a document that would then guide our committee participants. And as well as when you go into our national norm, there's a code of conduct that any individual who is nominated by his organization to represent that organization in our committees, we make them sign what we call a code of conduct for standard development participants on our left-hand side. And we'll see one of the issues that this code also emphasizes that the participant will sign is that you are going to behave ethically and legally, in that you are going to commit to support the principles of competition law compliance as provided for in the Competition Act of 1998 as amended, and shall conduct ourselves in a manner whereby we maintain and encourage effective competition in the marketplace. We also, or the participants also commit that they will encourage the reporting of unethical behavior, breaches of the Act, and matters detrimental to the SABS and its reputation. Therefore, that particular provision now that you've signed would then lead you to say, but here's a guideline that would then guide what are these issues that I need to be aware of as a participant that relates to the competition issues. So I've listed some of them, and I must add also, colleagues, this guideline as well, we don't sell it, it's freely available. If you need a copy of that document, obviously you are able to get that. But some of the key issues that we cover in that. So we are saying in the guideline that some of the things that you are encouraged to do as a committee member is that you need to limit your discussion or exchange of information during the standard development process solely to technical standardization issues, and only share information that is necessary to meet the objectives of standardization. So when we talk about, the manufacture of bricks, can we limit our discussion to the manufacturing of bricks? When we talk about, quality management systems or the competency of quality professionals, let's limit it to only those discussions. Secondly, we say we encourage you to consider carefully if a potential or actual exchange of information has any value in predicting the future commercial behavior of a participating competitor, and refrain from sharing any information that might have this effect. And lastly, like I say, colleagues, I've just uplifted the important ones, but you will see that the guideline that I've referred to goes into more details. That we must take immediate action if the anti-competitive behavior continues, including, this is now talking to the chairperson of the committee, as well as ourselves as the secretariat, the SABS, that we will take immediate action if the anti-competitive behavior continues, including suspending the meeting to remove the misbehaving participants or participant, and cautioning the remaining participants that such behavior cannot be permitted, and if necessary, adjourning the meeting. So there's a lot of responsibility on us as the SABS, hence this cooperation with the Competition Commission, that we are also empowered as the SABS personnel. Hence we are saying today also as our committee members, you are also empowered because some of you are chairpersons of these committees. Then on the don'ts, also not an exhaustive list, but just lifting the important one, the crucial ones, that what you shouldn't do as a committee participant is to discuss any competitively sensitive information. You must not exchange or discuss with competitors commercially sensitive or strategic information, including but not limited to data relating to prices, discounts, timing of pricing, changes, profits, margins, so the list goes on. And lastly, must not include elements in standards that exclude suppliers or competitors from the marketplace for any reason other than technical consideration. So this also places a very huge burden, or at least responsibility, on us as the SABS when we then apply that other document I've referred to called ARP 013, that then sets the rules for the structure and drafting of standards, that when we pick up something like that, that seems to seek to exclude others, that we will not allow it into our national standards. Colleagues, I'm just going to skip some of these, as you are well aware of, and I'm mindful of the time, but just to highlight some of the principles that we follow when we develop standards, key amongst them being consensus, the issue of transparency, and I guess transparency also talks to what we are trying to discuss today, that if you want to know, even as a member of the public, or even if you're not involved with one committee, and you say to SABS, who's involved in that committee? We will make that information available to you. Obviously, we won't tell you who's the person, the representative, or their contact details, but we could tell you the representative organization to say in this committee, we have company A, B, C, D, E, who are serving in the committee. So we have to be transparent. If you need to know about what we are doing, we will do that. Stakeholder engagement, this is what we are doing even today, where we need to engage you as our stakeholders, openness as well to new ideas that are brought to us, as well as due process, which is very key to what we do. I've spoken about market relevance in terms of the documents or the standard that we publish, that we're not just chasing the numbers. They must support something to show that there's market relevance. Excuse me. The development, this, colleagues, I'm just going to skip this very quickly, but I want to go to this slide just to show you how this can arise. So if you look into the stakeholder composition that we currently have on our database, and you go to line number 134, that you'll find that there are individual organizations, over 1,000 of them. And obviously, most of them, they compete in the marketplace. But when they come to the SABS, we are looking at collaboration, that we need to collaborate so that we can achieve the mandate of producing that. But the issue here is, when we've created this platform, that now the competitors are sitting here, there might be that temptation to say, you know, there's 5 of us here, 10 of them are not here, because obviously you won't have everybody and anybody sitting here. Others won't, you know, have an interest or direct interest, although the standard is going to affect them. But you can see that 65% of our stakeholders are individual organizations, which means these are competitors. Therefore, it is important that we must have this guideline to guide them as well. Then obviously you will then have other stakeholders like associations. So associations is also important because in their own right, they represent those other individual organizations out there in the marketplace. So we've got over 200, close to 250 of them sitting in our committees. And so we have this list. So those colleagues then says, yes, there is that temptation, or at least there could be that potential that organizations are tempted to then start discussing things that they shouldn't. So just to close it, colleagues, I've already indicated when I was talking to the issue of transparency, that if you want to know, even as a member of the industry, who is developing these standards, we will tell you, but we'll only give you the organization's name. So coming to representatives, colleagues, as you can see on your right-hand side of your screen, that we are also committed to developing standards that are gender responsive and gender sensitive. So we encourage that even as committee members, when you nominate those that are going to represent you in the committees, we really encourage you to start looking at female representation. Our numbers are not really looking good, colleagues. I think the last we checked, over 75% of those individuals that are sitting in our committees were all male. And we are saying, even responding to where our country wants to go to, where we really want to be represented, and including this declaration that we have signed, that we will encourage you that when you nominate your representatives, please consider nominating females as well, so that we can achieve this gender balance and gender responsive standards. Then on promotion and access to standards, colleagues, I know most of you are aware, but I just wanted to highlight this issue, especially if we've got regulators here with us today, that obviously access to standards is key. We want to make access to standards very easy. So there's a number of ways that we could do that. You could always subscribe to our complete collection. You could select whatever you want. We could pre-select for you. As an example, if you're in the energy sector, we could always recommend to you to say, you know, these standards will help you. And colleagues, this issue of subscription, I know sometimes we take it for granted, but I've seen even previously when one attends some of the workshops in the industry and you can see this industry expert who's respected by industry making a presentation. And when they start making reference to standard, you sit there and you cringe to say, but this individual is making reference to a standard that we were drawn 5 years ago. Because then they are not up to date. You know, a person would know about the standard still relevant without realizing that they change. But if you're a subscriber, you'll always be up to date. And then again, colleagues, to say why we can't just make standards available. We need to represent the copyright of standards. You know, we will refer to ISO, the IEC, and other organizations that we've got agreements with, and we've committed that we are going to represent the copyright. As you know, and I've repeated this many times now, that we don't reinvent the wheel. So if you want us to develop a standard for something, we look into the international communities if we can't find such a standard. If not, we'll look into the region, whether we go to Europe, whether we go anywhere, we'll bring that standard, but we also have a commitment to protect the copyright of those standards. And then lastly, colleagues, this is my last slide. What has happened? All right, this is my last slide. Colleagues, for many years since 1945, you know that we've been publishing documents where you could come here, get a hard copy, we give it to you, and then we transitioned where we can offer you paper-based copies or a PDF. You buy standard, you can download it. It's a PDF format. But the world is now moving into what they call machine readable standards, machine interpretable standards. You know, this whole issue of artificial intelligence where computers, or what they refer to as machines, can actually read the standard for you. So as the SABS, first step is that we want to convert our documents from PDF into XML. We've set ourselves a very ambitious target that by the end of this year, many, if not all of our standards should now be in XML format. And this, colleagues, allows you now as a committee member to be able to gain access to what we would now call data, not a standard. As an example, you could find that when you purchase a standard, it will have a lot of normative references, which you need those references to be able to apply the standard. But at times you find that to avoid duplication and causing conflict in our standards, when there's one clause in one standard and we want to refer to it, we will refer to that clause. At times, we don't refer to the entire standard. And when, for you to be able to get access to that, you need the complete standard. But where we are trying to go and make it easy for you is that you can then say to the SABS, I just want access to that particular clause or data. And then we are able to do that. So where we are going is that XML, it's going to at least allow us to be able to do that. Obviously, we will then, over time, go into the machine readable content when we are now transitioning to machine interpretable content, and obviously with the future extension thereof, because the standards across the world are evolving. And we've learned even from our partners that when we've now reached even just the XML stage, that it becomes easy to get the standard to the market quickly. You know, instead of saying to you that, no, if we want the homegrown standard, it will take us a minimum of 18 months. If we accelerate that development, maybe we can talk about 12 months. But some of our colleagues or our partners have shown us that actually it's even possible. I remember one of them said, average time to publication used to be 24 months. After we then transitioned into smart standards, that was reduced to less than 8 months. To be exact, they say 7.99 months to publish a standard. Madam Chair, that will be my last slide. I thank you. Thank you very much.
Thank you, Mr. Mashadi, for that presentation where you touched a bit on Standard Act, our processes, but also highlighting the element of alignment between the two with the Competition Commissioner Law Guide. Thank you so much. And now we're going to move to our next speaker from the Competition Commissioner, who is Mr. Shadrach Rambau. Mr. Shadrach Rambau, he holds a degree in MBA. Currently is the principal analyst in the advocacy and business administration. And he joined the commissioner as an economist in the market to conduct division and has been responsible for investigation, restrictive practices, abuse, dominances, and assessment of exemption application across various industries. Mr. Shadrach, the platform is yours. If you can take us through your presentation, please.
Thanks a lot, Chair. Everyone has been talking about his experience. I just want to indicate, Chair, that I've got plus minus 20 years experience with the Competition Commission. I'm going to project my presentation here, and perhaps you can indicate, Chair, if you are able to see that presentation. But maybe before I even do that, I just want to put on my camera so that as we go along, people will be able to attach the voice to the face. I'm sure you can see me on the screen, but I'm going to request that I switch off my camera so that I improve my bandwidth. So, Chair, I am trying to see if I can be able to project, and you can indicate if you are able to see the presentation, Chair.
Yes, I'm able to see it.
Thank you. So thank you, Chair, again for giving the Commission the opportunity to engage with relevant stakeholders on the joint guide. I just want to indicate here that our focus as the Commission today will be on standard setting from the competition law perspective. In particular, the presentation is going to highlight some of the risks that may emanate during the standard setting process. I just want to indicate here, Chair, that our objective is to level that playing field that Mr. Matlare projected. We want to level it. You could have seen, Chair, that that playing field was very much uneven. We want to level it so that everyone, big and small, will be able to fairly compete in the marketplace. I thought that we must perhaps start with this disclaimer. This joint guide that we are talking about was prepared in terms of Section 21 of the Competition Act as amended. The disclaimer is that this is not a practice note. This is also not an instruction note. We do not want colleagues and attendees here to confuse the joint guide with those instruction notes that National Treasury normally publishes that are binding on the part of market participants. And we thought that let us make it very clear, the guide is not binding, but it may be taken into consideration or into account by any person during the standard setting process. I'm trying to move my slides, Chair. There you are. The purpose of the guide, as previous speakers have alluded to, this is to raise awareness and to provide broad guidance on competition law issues to market participants in the South African standard development process. Who is the target audience? As you can see, Chair, the target audience of the guide, mainly it will be SARBs and its own technical committees. So you've got chairpersons of those technical committees, you've got representatives of participating and observer members. You have secretaries of the technical committees, subcommittees, as well as experts and conveners. Those are our main audience. But of course, we are not going to prevent anyone, any person who wishes to use this guideline. But bearing in mind the disclaimer that we have given, right at the beginning of this presentation that this guideline is actually not binding on anyone. It is not binding on the Commission. It is also not binding on SAPS. These are the objectives of the Competition Act. Mr. Gwabeni, in his introductory remarks, he highlighted some of these objectives. And one of the reasons why we have decided to draft and publish this guide, it is for those three highlighted objectives. Those are the main ones. I mean, of course, if those three are satisfied, all the other objectives will be able to be met. The first one, it is to provide consumers with competitive prices and product choices. Secondly, we want to ensure opportunity for SMMEs to participate fairly in the economy. And then lastly, we will be promoting a greater spread of ownership, particularly for HDIs. We acknowledge, colleagues, as the Commission, that standard setting plays a very critical role in industrialization. We also acknowledge that standard setting has a positive impact on prices and innovation of consumer products. But while there are significant pro-competitive gains or benefits from the development of standards, we therefore cannot ignore the potential anti-competitive risks that could arise from communications and deliberations amongst competitors, both inside and outside the SAPS technical committees. We have identified two very broad anti-competitive effects here. The first one, which Mr. Matare has alluded to, is possible facilitation of collusion between competitors. We know that in these SAPS technical committees, some of the members, as Mr. Matare has indicated in his presentation, some of the members are competitors. And during these discussions, there could actually be a possible facilitation of collusion between competitors, and that conduct on its own is a violation of Section 4 of the Competition Act. The second possible anti-competitive effects that might arise from the standard setting process, it's possible exclusion of new entrants by incumbent firms or the dominant firms. There is that possibility that the standard can be set so high that it actually becomes very difficult for new entrants who are in the main your SMMEs and HDIs to be able to enter the industry and compete. And these are some of the problems or the issues that we have identified in the complaints that we have previously received as the Commission. So collusive outcomes, you can see from that slide, standard setting process may lead to collusive outcomes when market participants who assist SAPS in standard setting have the ability to limit competition through their coordinated effects. Standard setting process can also be used to facilitate collusive agreements. And those collusive agreements have the effects of minimizing product or service differentiation. I just want to indicate here, Chair, just give context to this slide. What we are saying here, Chair, is that coordination of responses and submissions by competitors to the SABS technical committees, this is not only bad to competition principles, this is also bad to your own processes of standard setting. And I just want to give an example here, Chair, that in a case where you have a technical committee that will be looking at the development of a particular standard or the reviewing of a particular standard, and you have 5 competitors that are part of that committee. I mean, of course, Mr. Matlare has indicated that over and above competitors, there are other members, NGOs and others that also become part of these committees. But in a case where you've got 5 competitors that are participating in assisting the committee to review or to develop a new standard, in a case where out of the 5 competitors, 3 decide to coordinate their own responses or submissions, in that case, Chair, we are saying in practice, rather than that committee having 5 members who should be coming up with different views in the development of the standard, in practice, then it means that the committee only has 2 members. Because if 3 are coordinating their own responses and they are coordinating their own submission, in so doing, that limits the amount of information that that committee will be able to derive from participating members. And it actually deprives the committee the amount of information that that committee requires for its own decision-making processes. So that is why we are saying this is not only a competition issue, but this is also an issue that can affect your own decision-making processes in these various technical committees. With exclusionary effects, possible exclusionary effects that might emanate from standard setting, these are effects which in the end, they can exclude a number of firms who would ordinarily comply with the standard requirements. But because the incumbent have actually decided to raise the bar so high, it actually becomes very difficult for your HDIs and smaller firms to be able to meet that requirement. And as a result, it might be difficult for the SMMEs and HDIs to be able to enter and compete in the market. I want to give you a very simple example here of one of the cases that we have received. As Mr. Gwabeni has indicated, we have received quite a number of complaints, but I thought that this particular complaint, it is more relevant to the discussion at hand. We received this complaint about pressure valves on geysers. The complainant is an importer of geysers from China, and these geysers do not have a pressure valve. The complainant in his complaint, when we were interacting, when we were having discussions during the investigation of the complaint, he indicated that the standards at the time requires all geysers in South Africa to have a pressure valve. And his argument throughout the investigation of that complaint was that this is not an important feature on a geyser. Yes, you can have a pressure valve, but this is not something that it is core to the functioning of a geyser. And his main argument was that this feature for a pressure valve has been included by incumbents. He was alleging that some of these committees are dominated by competitors who are dominant, and as a result, because they are manufacturing geysers with pressure valves, they made it a point that any geyser without a pressure valve does not pass the SAPS standard. I can tell you now that we engaged different stakeholders, and it was our understanding at the time that this pressure valve, it's a safety feature on a geyser. So even though the complainant has been arguing that this is not important, you can have a geyser without a pressure valve. That is the kind of information that we managed to gather during our investigation process. And I can tell you now that we eventually non-referred and closed that investigation. Not on the basis of whether or not the pressure valve is important. As the commission, we wanted to err on the side of caution, because we were told that this is a safety feature. Although the complainant's counter argument was that this is not important, a geyser can operate without this valve, we decided that as the commission, because we are not experts, let us rather err on the side of caution. But perhaps the point that I want to highlight is the point that I have highlighted in my previous slide, that sometimes there are features that are not really core to the functioning of the product that might be included in the standards. And incumbents will advocate the inclusion of that feature solely for purposes of exclusion. So perhaps what we are saying here is that it is important that if the SAPS technical committees are discussing all these features that are required for a proper functioning of the product, it is important to be wary of competitors who would actually want to influence a particular standard in order to exclude. And this is a general comment. I'm not in any way saying that this comment applies to this specific case. As I have indicated, we eventually non-referred because we were told that the pressure valve, this is a safety element, and we came to the conclusion that as the commission, we cannot make a determination of whether or not this so-called safety element is important. But perhaps I just want to indicate here, Chair, that over and above the issue of collusion, where competitors will be coordinating their own submissions, which I have indicated that that is not good for competition law principles, but it is also not good for your own SAPS processes. We have actually identified other potential anti-competitive effects that are not related to standard settings and not related to the guideline that we have published. But we then thought as the Commission Chair that because we will be having some stakeholders that are relevant to this, let us perhaps as the Commission highlight some of these issues that are on our radar. And the main issue here that we will be looking at, it is the issuing out of the compliance certificates, COCs, by voluntary organizations. We do acknowledge, colleagues, that there is a regulatory gap. There is a regulatory gap. We got to understand when we were investigating some of the complaints around the issuing out of COCs, we got to understand that in the past, there were local municipalities that were performing this function. So a local municipality, a work will be done, a local municipality, an inspector will come and issue out the COC. But we were then informed that as a result of capacity issues, these local municipalities are no longer performing that function. And that is why, Chair and colleagues, we are saying we do acknowledge this regulatory gap and the fact that these voluntary organizations, they've come to the fore to start issuing out these certificates. And this has become an industry practice, Chair, that no service provider can perform an insurance work and be paid without this COC. And perhaps the problem that we have here, colleagues, it is not so much that the COCs are being issued out by voluntary organizations. The main problem that we have here is that membership of these voluntary organizations, it's actually very difficult for your HDIs and SMMEs to gain membership. You look at application fees and annual fees that are supposed to be paid by members. They are so exorbitant that it becomes very difficult for a new entrant and to be able to become part of the voluntary organization. And if you are not part of that cluster, you cannot do insurance work, because for your claim to be paid, you need a copy of the COC that should be submitted to your insurer. So this is an issue that we are currently looking at, and perhaps what we are saying, if there are these voluntary organizations that are currently issuing out COCs, perhaps you must start looking at ways in which non-members can be accommodated. Because as the Commission, we cannot afford a situation where your HDIs and SMMEs are excluded simply because there is a COC that is being issued out by a voluntary organization, and membership fees are so high that it becomes difficult for these smaller players to be able to become members and do the insurance work as it is required. In conclusion, Chair and colleagues, there are three main issues that we have identified in this presentation. On the issue of coordination, what we are saying, and this is what we have observed even when we were investigating our own cases, what we are saying is that perhaps the subcommittees must look at patterns. We have investigated quite a number of complaints in the past, And these complaints, sometimes the respondents will be the same. It will be the same organizations. And when you then look at the responses that we receive from these two different organizations on different issues, they are always aligned. It cannot be a coincidence. And perhaps that is why we are saying subcommittees, when they are looking at issues relating to standards, they must look at patterns. I mean, I'm sure there are organizations that you regularly work with. If you then look at those patterns and you find that certain market participants are always aligned on different issues, this could actually be evidence of coordination. And we are saying that in such cases, you must closely scrutinize these submissions. It's actually very important to always scrutinize such submissions. The second issue, on the issue of exclusion, which is an issue that we have just discussed relating to pressure valves, we are saying subcommittees must ensure that they include features that are necessary to standard setting and ensure that those features are not designed to exclude competition. So subcommittees must be able to justify the inclusion of these elements, and they must be able to defend such an inclusion. Because of course, in a case where there is a standard that has been developed, there are going to be smaller players and HDIs who are going to challenge the inclusion of some of the features in that standard. So it is important, as we are indicating here, that the inclusion must be justifiable and we must be able to defend. On the issue of COCs, we are saying that maybe let us start encouraging these voluntary organizations to start looking at ways in which non-members can be accommodated. It is important that we must be able to accommodate non-members. It is important that even in terms of our own membership, if it means dividing membership into two categories, so that at least you can set a bar low for HDIs and SMMEs, please do that. If it means that for non-members you can have a very small fee that you can charge to issue out these COCs, please do that. We are basically saying here that this is an issue that we will be looking at, and we will be engaging with all relevant stakeholders in the near future. Chair, that is my last slide. Thank you, Chair.
Thank you, Mr. Rambau, for that detailed presentation, which is actually linked to what some of your office has received and actually have investigated, and also for the recommendation that you have given to the SABS. We really appreciate. I'm not sure if Dr. Satbiri, you would want to say something, or I can go straight to questions and answers.
Thank you, Tundani, and thank you, colleagues, for the well-articulated presentations. So we've been in the background trying to respond to some of the comments and some of the questions that have been posed as well. I trust that we've been able to address at least most of the comments and the questions posed, and we'll certainly get back to you if we haven't addressed some of the comments. Tandani, at this point, I have nothing further. There are one or two comments and maybe a question or two that has been raised that I have not responded to, and maybe it's directed at the Competition Commission presentation. So at this point, I'll stop here and thank you for the opportunity once again. And you could, I think the next point on the agenda would be on a Q&A session on questions that haven't been addressed, and will be guided by yourself on this. Thank you.
Thank you, Dr. Satvir. I will open the platform for those who have questions, and they haven't actually posted them on the chats. I can see by the indication of raising of your hands. Okay, I see. I'm gonna take the first three hands from Gavin, followed by Tavisa, and then followed by Silaelo, in that order, please.
Morning. It's Gavin Adamson here. I've got two questions. It's a twofold question. So I understood the presentation and thank you very much. It was very informative. But I'm not getting context to two questions from both the competition and the SABS. Question number one, we seem to be functioning as an island without ARSO because the rest of Africa is drawing up standards different to what we're drawing up standards in South Africa. And given the recent AFTA agreements, I can't get clarity on where that's all headed. That's my first question. I presume it goes to the SABS. The second question is, the Competition Commission is trying to prevent anti-competitive behavior, but a true statistic is that the examples given and many things, we are losing the manufacturing sector in all spheres of life within Southern Africa. And it's true that that sector needs specific protection, anti-competitive protection from the rest of the world dumping its products. And many of the committees that I'm aware of are now 100% represented by only importing parties. They have no manufacturing legs to the technical committees. And so we are changing from a situation where the technical committees were substantiated and populated by manufacturing, who no doubt I can understand maybe had some anti-competitive, hence the reason for the meeting. But if we have no manufacturers, it becomes a farce to fix the problems we're trying to fix in the country of unemployment. So those are my two questions. I'll switch off the speaker now. Thank you.
Thank you, Gavin. Tavisa, you can ask your question.
Oh, thank you, Tendai. Okay, just maybe two brief questions, I think, in a comment. Why is this guide not binding? That goes to the Competition Commission. And secondly, to the SABS, and I think Mr. Shadrack has alluded to this about these anti-competitive behaviors in the committees. One of my experiences that I've seen is that in the committees, you obviously have, these incumbent organizations that have been long in the industry. What is the SABS doing to ensure that HDIs, I think it's Mr. Ramba who said that historically disadvantaged individuals are included in these committees? And I say this because I've been to certain committees where I see it's historically people that have been there for long. And even when there's working committees that need to address a specific issue, it's the same people. Now, obviously, I'm not apportioning blame or saying there is something to that effect, but there's now an incentive to ensure that the people that are already in the industry are creating moats around themselves using the very same standards, because there is not enough representation in these committees themselves from the historically disadvantaged. And I also want to cite another example of a standard called SENS 1393, where there was no uptake. It's a construction management system. Now, this is obviously designed for the small construction companies. There was no uptake for it. And we did a study with UJ to find out why are people not taking this. And you could tell immediately by just reading the standard that it was so exclusionary. It was treating a small construction company the same as we would treat a Stefaniti Stocks or a Wilson Bailey Homes. And there was just no way those companies could adhere to that standard. And the CIDP themselves were encouraging the public and private companies to request for this standard. So I just want to know from the SAPS side, what are we doing to ensure that we are including in every committee these historically disadvantaged individuals when these standards are being set? Thank you, Tondai.
Okay, thank you, Tabitha. I think I'll take the dialogue before actually SAPS and the Competition Commissioner can respond.
Thanks, Tondani, and thanks to the chair and all those who presented. My question revolves around the same issue as the competitive collision behavior within the audio video automation industry big players, which is monopolizing the AV automation market, which limits product options that are shipped within South Africa. And this as well harms the new entrants to the AV industry, since there's a lot of pricing monopoly. For one, an AV product offered in South Africa in terms of price as compared to the same product that is offered in the US. There is a huge pricing difference. The one in South Africa is highly priced, and I'm asking what control measures do we have in place so that we can regulate these anti-competitive practices? Thank you.
Thank you, Selailo, Tabitha, and Gavin. So I'll give the opportunity for SAPS to respond. I'm not sure if SAPS first or Competition Commissioner first. Because Competition Commissioner, there are two questions actually that are directed to you on the anti-competitive behavior versus the loss of manufacturing. Consequently, the lowering the effectiveness of our economy. And the second one being that the guide, why is it not binding?
Thanks, Tondani. Very quickly, I'm going to take the most easiest questions. I will then let my colleague, Mr. Gwaben, to come in. On the reason why the guide is not binding, I indicated right at the beginning of my own presentation that this guideline was published under provision 21.1. So under that provision, it should be clear that anything that gets published under that provision, it is solely for awareness purposes. And we are providing broad guidance on how standard setting process should actually be done. But rest assured, I just want to indicate here that in a case where you are aggrieved, you've got a complaint that you want to lodge with the commission, we will investigate that complaint, and whatever outcome, that outcome would actually become binding. So the fact that the guideline is not binding does not necessarily mean that when investigating, we are not going to be following some of the elements that we have highlighted in that guideline. If you come to the commission, we will investigate your complaint, and the outcome of that complaint will therefore be binding. On the second issue regarding the issue of dumping, we are also concerned with issues relating to dumping. We want to protect our local manufacturing sector, because in that way we will be protecting local jobs. But perhaps the point that we were trying to make in the presentation was that we do not want a situation where SARBs, the objectives of SARBs become a place where they will be preventing issues relating to dumping. I mean, there are very relevant institutions like ITEC that will be looking at such issues such as dumping. The point that we were trying to make in the presentation is that let us not have features in the standards that are not important, that are there simply to exclude competition. Because in as much as we do not want issues relating to dumping, we also want consumers to have product choices, but to also obtain these products at very low prices. I mean, of course, we are not going to be compromising the issue of safety in the name of having lower prices. And that is why SARBs is there to look at issues relating to standards. ITEC is there to look at issues relating to dumping, but otherwise, standards, we must make sure that all the elements that we include in the development of those standards are very important to the functioning of the products that we are looking at. On the last question regarding monopoly in the video industry, I am saying if there are such issues, you are at liberty to come to the commission. We will investigate that complaint and give you, make a determination, give you feedback on how we went about our own investigation. But perhaps I will allow Mr. Gwabeni to come in through you, Chair.
All right, noted. Mr. Gwabeni.
Thank you very much, Chair. As much as I think Shadrach has covered the broad strokes on the answers, I just want to emphasize 3 points. The first thing is that the Commission and SARBs flowing from these guidelines would have a joint responsibility to advocate for both compliance and also for us to be sensitive to the competition issues that arise in the standard setting process. So I think this is something that we need to invest a little bit more on and ensure that we are able to get it out there that as we are setting up these standards, we also have to be conscious of the implications of the process so that they do not become inordinate barriers to entry for SMEs and also for HDPs. The second issue for me is that there is a need, more especially for standard setting bodies, to begin to look at empowering and of course making it easier to understand these standards and also to empower these firms to be able to meet these requirements, because we do recognize the importance of safety standards, the importance of quality, because that adds to the welfare of consumers. But we also have to be conscious of issues around price, of issues around choice, and of course, issues around inclusion. And I don't think these should be seen as antagonistic. These should be managed in a way that we are able to accommodate and to balance all of these issues. And lastly, Chair, I think that for us, we remain committed to investigate any conduct that violates the Act, but we also want to be available to share, as we are doing today, to share how people can comply, because we don't want to be using the stick, so to speak. We would like to create an environment where all of us are aware of the objectives of the Act and voluntarily we work together to create the economy that we want. Thank you, Chair.
Thank you, Mr. Andile. I absolutely agree. They said knowledge is power. So the more we keep in touch and constantly communicating, the better we can execute this task, especially between the SABS and the Commissioner. I will afford the SABS an opportunity to respond, and then the next, and from there I'll take the next set of questions, which is gonna be the last. So after the SABS has responded, I will hear from Chauke, Tabo, and Andrew. I saw Bright has lowered his hand. I believe that in the process of, okay, the hand is up. So these are three people that's gonna speak or ask their question briefly. And then from there, we'll be closing the webinar. It's almost 10 to. From the SABS, there's a question that we are operating in silos. So it's like an island. There's an agreement that is signed. SABS is not visible there. And the other one is around our stakeholders. That seems like as if we are keeping only the old stakeholders. We are not open, okay, not open up, but then the person wanted to hear the strategy about getting on board the historical disadvantaged individual in our strategy, if I may put it that way.
Thank you, Tondani. Gavin, thanks for the question. My assumption is that, and maybe I didn't hear you correctly, that you are part of a specific technical committee at the SABS, so you would have an understanding of what's happening in that particular technical committee, including alignment of work with the regional body also. So for colleagues who may not have this type of engagement, we are working very closely with ARSO. We are a full member of ARSO, and we have a number of leadership positions at both governance levels as well as technical committee, and participate as actively as we can based on the technical expertise that raise their hand to participate in ARSO technical committees. So just as a background, ARSO has at one stage had 13 working groups, if you could put it that way, because they've restructured, and all of these areas or thematic areas of standardization has moved to about 83 technical committees and subcommittees. And that took place about 2 years ago. And they opened up for the 40-member ARSO member states of 55 countries to participate in their technical committees, contribute towards the development of ARS, African Regional Standards. SABS currently participates in around 35, or are members of at least 35 of these technical committees and subcommittees. Now, you would know that in order for us to participate in a technical committee at a regional level or at an ISO level or an IEC level, we need to have an identified experts, either as a working group, portfolio, a technical committee, or a subcommittee. So we only mirror the work of ARSO, where we have fully established a participation model, either TC, working group, or SC. And if we don't have that, there's no way that we can participate, because everything stems from discussions, resolutions, adoption strategies from the technical committees, from the working groups to the TCs for resolutions. So that's the model of working at ARSO. So we are working very closely with ARSO. There are a number of experts, and maybe one or two of you are represented here in this forum as well, that participate in the adoption of ARSO standards. So I don't think we're working in silos. I think we are not engaging as much as we should be in terms of getting the right experts into majority of the ARSO technical committees and establishing harmonized standards. Now, there's one thing for us to really appreciate. When ARSO adopts, ARSO has no authority to adopt an ISO and IEC standard. It is done through notification. So majority of the standards that we have adopted from ISO and IEC per se, and ARSO has recognized and notified them, we don't need to re-adopt them as harmonized standards in ARSO level. So that's something that's quite important for colleagues to understand in terms of developing a separate ARSO standard or harmonized standard, where we have already adopted the same identical requirements at ISO and IEC. So, but there's a lot of work that's happening at ARSO. Gavin, to your point, is it enough? Certainly it's not enough. The world of standardization is evolving very rapidly. The scope of work is evolving very rapidly. ARSO, together with the AFCFTA, as you pointed out, is literally the focus of the entire world in terms of what's happening. It's certainly not going to become like a second European Union in terms of their modalities and methodologies of harmonization of standards. We are pretty unique. We are very diverse in terms of our capacity, maturity, capability, and technical experts in the 55 member countries in Africa. Some national standards bodies has 1 or 2 or 3 members to the national standards body compared to South Africa, which is one of the bigger ones. And specifically in our standards division, we have about 80 members participating regionally, nationally, as well as, 80 staff members participating regionally, nationally, and internationally as well. So I trust that provided some element of understanding and clarity as well. The manufacturing center, I think we have to just get a little more information around the bold statement around technical committees having solely importers or majority of importers in our TCs. We don't generally accumulate all that activity, those types of data that in our technical committees to determine whether you're an importer or a local manufacturer. I can tell you now, majority of the colleagues that or industries that I've engaged with, they have a hybrid model. That's just how the economy and the global value chains have evolved. A hybrid model whereby you either manufacture together with adding an element of enhancement on a particular component, etc., which is not necessarily purely manufacturing. So it's twofold. So it's very difficult to get that data. But I do acknowledge and take note of your concern on this matter, and where we can address it, we'll certainly look at it. Tabiso, your comments around HDIs. So historically, members that have been there for a lengthy period of time. Sure, we want members and enhanced membership to our technical committees and enhanced participation in our technical committees. Currently, we have in excess of 2,000 members participating in our committees. And Peter provided you with an indication in an earlier slide on the composition based on the stakeholder representation themselves. So we have a fair share of academics, we have a fair share of colleagues who are participating and associations, professional bodies, regulatory authorities, which are pretty much a key part of our stakeholder engagement. And certainly in terms of individual companies, we have in excess of 1,100 companies, individual. And these are maybe big companies, it may be small companies. So there is no area of focus that we would like to emphasize on, be it big or small, but we encourage every single interested party that has the capacity and capability to participate in a technical committee, subcommittee, or even a working group. You don't need to be part of a TC per se to really participate at any given point in the development of a national standard. You can participate and submit your comments outside of a committee, whereby we have public inquiry and we gazette these standards out for public inquiry, where every single citizen has the opportunity to contribute. But your point is well noted. SMMEs are a focus for us to engage more with SMMEs, and we get the intel from the committee members themselves in terms of who else we should be approaching to enhance the uptake of standards. Now, going beyond that, in terms of promoting an awareness, you might be aware that SABS over the last year has gone on an expansive promotion and marketing stint on the SABS. Colleagues, there's somebody whose mic is on. If you could mute your mic.
Facial recognition technology.
So we've got an expansive promotion marketing stint on the SABS, including the development of national standards and how you participate. And this is not really to the big suburban areas, etc. It's to the areas that require capacitation and understanding of standards, like the rural municipalities. And we've done significant roadshows together with the regulators like NRCS and worked with the DTIC and a number of stakeholders. And we will continue with that. So that is our initiative, to get colleagues to come in and participate in our TCs. But the commitment is, once you are a member, you need to adhere to the rules. You need to participate. If you're a P member or O member, that differentiates your participation rate. You need to contribute toward the technical content of that standard. And we find that quite difficult, even in our current matured committee members, whereby we don't get as much comments on specific documents for conclusion of the documents for whatever reason, and the projects hang for a period of time. Bearing in mind there are challenges internally within the SABS as well. So there is engagements on getting participants outside of the normal traditional historical committee members that actively participate in the technical committees. I think those are the two significant ones that were highlighted. I'll stop there in cognizant of time. Thank you, Tandani.
Thank you, Satvir. It's almost 12 o'clock.
Sure.
I'm not sure if participants could allow us to proceed. Sorry, somebody's talking at the background. Please mute your microphone.
Yeah, manje bangivalidator ikunikeza leya.
Okay.
All right, thank you. I'm not sure if we should take the last set of hands of the 3 people that I've indicated, and I see there are 2 more. I'll request the last 2 to put their comment or their submission through a comment section, and I'll request the SABS team and the Competition Commissioner team to respond to them in the meantime. Thabo Chauke, Andrew, and Bright in that order, just 1 minute. And I'll request if the participants are okay with us going over and above 12 o'clock with 5 or 10 minutes or so. Then.
Okay. Good morning and thanks, Tandani. My question is directed to Competition Commission. I want to request from them to explain, given the nature of the work at the technical committees, which can be ad hoc in the sense that standards, once they are set, the committee dissolve, or at least the members have to dissolve. So how are you going to deal with this issue of cohesive agreement which are reached tacitly? Because I mean, in competition balances, this is a difficult area. Even competition, they grapple with this issue, and I just wonder how do they? How do they think a body like technical committees can be able to address collusions which are, reached in a tacit manner. Thank you.
Thank you, Thabo. Quickly, Andrew, 1 minute.
The technical committees are typically invite only, and it's not necessarily always clear on how those invites are generated. The question is that typically, if it's from internal within the technical committee, then it's typically remains the same set of people or the people who are visible to that set of people, typically large organizations or large companies that are currently incumbent in those committees. And the question is, how do you raise the profile of the SMME potential participants or the people who are skilled enough to go into those committees, given that kind of current setup?
Thank you, Andrew. Bright.
Chair, mine is a comment, and I'd like to say I'm coming out in defense of SABS. I've been participating in SABS technical committees for a number of years now, almost like approaching 20 years. What I've noticed is that member companies, they register with SABS, they give committee chairs the names of representatives. Then when we send out invitations, we phone them, guys, come, let's participate, let's have meetings, let's have this. Somehow people these days are always busy. And that's a fact which I'm seeing there. Like what Dr. Sadvir said, these committees, you can join at any time and all that. But what I'm seeing is sort of an apathy. And particularly the guys who don't want to point out one industrial sector, but the guys who are importing material, they register, and when you want to discuss things, so that's why you always see in certain committees, similar people participating. Then one last point is on the engagement. We feel that SABS is our own. We are the industry. We create the standards, but SABS governs and look after our standards and controls that. So SABS needs our participation. SABS needs our support. It should be the other way around, not SABS coming to beg us to participate in the standard generations, but we should take it that this is our industry. We create the standard. We support our own SABS. I've seen it, what happens with the Dean guys in Germany. I've seen what happens with Australian standards. Industry participate fully in way up to ISO. So that's what we really need here in South Africa. I know people say, oh, where is SABS and what's happening in SABS, but yet it has to be the other way around. We are supposed to be pushing SABS. Thank you.
Thank you, Bright. I think the SAPS, if quickly you can respond on the issue of the SMME participants in our committees and the issue of lack of participant resulting in the same people participating and also not using other avenues that are provided there. Because time I understand, but there are other avenues that SAPS has put in place.
Thank you, Thandani. So I'll be very brief because I think I addressed the matter of SMMEs and how we are engaging them and how we attempting to promote a wide audience and participation of members in our technical committees through these various roadshows that we engage on as well. Now, anybody has the opportunity to apply to become a technical committee member. Anybody. There is no restrictions on TCs, and that's why you would see associations are 200, individual members, companies are 1,100. So please feel free. And where you know colleagues, which we don't have sight of anyway at a particular circumstance, where you know colleagues who are very interested to participate and become members of a technical committee and participate. And that's a critical word, right? You 100% in terms of where you're coming from, and it shows a vast amount of experience that you've had in the technical committee, both at national and international level as well. So we're open to all representatives and a diverse range of representatives as well in the technical committees. And we'll continue with SMME engagements on participation. The issue around committee dissolves, there's no dissolution of committees, colleagues. Once you participate in the committee, you participate in the entire scope of that work, either a technical committee or a subcommittee, depending on the tiers or the number of committees established within the subcommittees established within the technical committee. So generally, we wouldn't want you to come in and contribute to one standard. No, it's to the entire scope of the work. And we expect a participating member, including an observer member, to engage with all submissions. And it's a plethora of submissions in these various TCs and SCs for your active participation and contribution. What we find is that colleagues have a tendency who are sitting in the technical committees, for whatever reason, don't participate, contribute, even ballot in a technical committee that they are participating in, and then go out in public inquiry where they had the opportunity in TCs to respond, and at public inquiry, there's an issue and they raise it at public inquiry, which is all the wrong platforms to engage. So active participation as members in the TCs are vital because you have been given the opportunity to participate in those committees as a member. Reviewing committee participation is also something that we need to actively engage on because we need to implement and enforce our own rules. It says that at a particular point, we need to review, possibly on an annual basis, the membership, the participation. If you're not participation, what happens thereafter? But Brett, you hit it on the nail there. We can do as much as we want, and we continue to do as much as we can to ensure that committee members and relevant committee members are sitting in our TCs or experts in our TCs to drive the technical content of the documents in our technical committees. And the last point that I would just like to say is that research, evidence-based scientific information, including case studies, all these are submissions through the technical committee that is considered to ensure that the right information is considered in our technical committees, not knee-jerk reactions on a comment by an individual, and that now is taken as an inclusion into a technical requirement of a standard. We're very concerned if that should be happening. We will address that accordingly. But from my perspective, research-based, evidence-based submissions are quite critical, and that's why we focus on ISO and IEC as the first and foremost establishments recognized by the WTO to adopt these international standards and nationalize them as South African national standards. The strategic value of standardization is really underappreciated by a lot of the industry participants as well, because industry participants, they should well know that participating, engaging, influencing a particular standard has a fundamental impact on your market accessibility, market penetration, and it shouldn't just be on a domestic market. We are living in a globalized world and continue to be, despite the issues and the conflicts that we are experiencing globally. We are living in a globalized market. International standards are key for adoption so that we can now submit and allow for the ease of products and services in the African continent first, as to the colleagues alluded to, and obviously maintain our influence in the international markets as well. And that is the strategic value of standardization that a lot of committee members really appreciate and understand and continue to participate actively. But as we bring along new members, these need to be articulated as well, because the question is, what is the benefit for me to come into a technical committee to participate? An example of DIN implements a system of membership fees. That's how important it is that members feel their contribution towards the technical committee is, that they pay membership fees to participate, contribute, etc. So we're not mature in that level. Obviously, we don't want to expose a membership fee model for South Africa just yet, because we are funded by DTI to do the work. But things could evolve as we mature the system and as we mature the market and the strategic value is being appreciated in the market on standardization. Thank you, and apology for a lot being said at this point, but I thought it was important to relay this information. Thank you.
Thank you, Satvir. The Competition Commissioner, just 1 minute, and then we close the meeting. On the question, how will the TC then be able to actually see or pick up the issue of?
Thanks, Chair. Very quickly, we just want to indicate here that all the engagements that we are having with SAPS the joint guideline that we have drafted and published. These are preventative measures that we are trying to implement to ensure that issues around collusive agreements inside and outside the subcommittees does not materialize. If you look at the last section in that guide, we've got a do and don'ts section. We have highlighted all the things that can be done, all the things that cannot be done. And in that way, I think, unlike in the past where we will simply receive complaints once the standards have already been published. In this way, we are trying to be proactive rather than being reactive. Thanks, Chair.
Thank you, Shadrach. I think that's where we're gonna end today. And I would like to thank all the participants, our speakers and presenters, and the organizing team that have helped putting together this webinar. I really appreciate. And let's continue doing right, raising the South African standard development flag, by so doing uplifting our South African community and economy, and be impactful to the whole world through standard development arena. From me, it's gonna be a goodbye for now, and enjoy your day further.
Thank you.
Thank you, colleagues. Bye.
Thank you. Bye-bye.
Thank you. Bye.
Bye.